manager of WorldD and data protection officer. So it's my first summit, so I'm very happy to be here. And this session confirms the General Data Protection Regulation, GDPR. It will become active on May 25th, 2018. Who has heard about GDPR? Please raise your hand. Great. Compliance doesn't have to be scary, even if the deadline is fast approaching. I will give you the best guideline. And this morning you received a USB key. That's right? You have your USB key? Great, because in this key you will find much more details. Many example tips for setting up your tools and your organization. I'm not alone today. I want to introduce you Mr. Chouachi Hakim at Identifiable. He will explain how the GDPR affects the hosting. And Mr. Julien Brunet, a lawyer at Spring Legal firm, is our trust partner, and he will be available to answer your questions at the end. And if you need a face-to-face meeting with us, we are available during the summit next to the reception. So let's start with the summary. So GDPR is a very wide subject. So I'm going to see with you the first 8 points for the moment. Applicable rules. What does it mean? Each member state has its own competent authority, and each member state has its own local law concerning personal data. Keep in mind 2 points. If you are an incompatibility between GDPR and your local law, GDPR wins. Second point, concerning some points, member states can have an interpretation more restrictive. In that case, this interpretation most restrictive wins. Is it clear? Okay. So now it's important to know if you are impacted by this GDPR. Are you affected by this GDPR? You have to ask yourself 3 questions. Do you handle personal data? Il y a un problème avec le microphone? Non, it's okay? It's okay for you? Okay. Do you handle personal data? Personal data means if you can identify someone with direct or indirect information, it's a personal data. For example, your name, your last name, it's a direct information. Your car register number is indirect information. But your personal data becomes a sensitive data when it is disclosed, it could harm a person. It's a very important point. For example, video watching, it's a sensitive data. Be careful. The list of sensitive data may be different because member states can have their own interpretation. So keep an eye on your local law. Normally, concerning sensitive data, it's forbidden to collect them. But there is a lot of exception. If you, for example, if you have the consent, it's possible. The storing, the sharing, consulting, even the deletion of data are regarded as treatment under the GDPR. If your connect presenting a high risk to the right and freedom of natural persons, you have to make an additional action. You have to make a privacy impact assessment. You have to evaluate on the USB key, but if What's your role? Are you data controller or data processor? The data controller determines why and how personal data are or are to be collected. This is a decisive point. Data processor means a company processing personal data on behalf of the data controller. So, to determine if you are a data controller, you need to ascertain who decides to collect the personal data, the content of personal data, the purpose or purposes the data are to be used for, and how long to retain. The final criteria is very important. The goal of GDPR is increasing territorial scope to protect all European citizens. So, GDPR applies to all companies in EU, regardless of their location. And even the data controller or data processor are outside the EU, the GDPR applies to if they provide services to a European citizen. For example, an American orders something online from a French startup. He will give his personal data for delivery in the US. So the GDPR will be applied because it's a French startup in EU. Now, how to organize the relation? It's a very important point because before the GDPR, the data controller wasn't responsible. Data processor, wasn't responsible. Now, data controller and data processor are responsible. But it's very important to formalize your relationship in your contract. It's very important to specify the data processor only process data on documented orders from the data controller. Documented orders is very important because it's a proof of your action and it's a proof of your compliance. Why it's very important? It's very important because the data processor is only responsible in 3 cases. If he doesn't respect the obligation set out in the GDPR, if he acted outside the legal instruction of the controller, and if he acted contrary to the controller instruction. So, it's very, very, very important to be clear in your contract when you start a project. So, now we are going to see 6 principal points. It's very important to understand them because if you don't understand them, if you don't respect them, your treatment will be illegal. Let's start with the first principle, lawful, fairness, and transparency. This principle means you have an obligation to tell data subject what their personal data will be used for. The second principle is the limitation of purpose. The personal data collected for one purpose can't be used for new incompatible purpose. An example, a company provides insurance services. Over the year, this company collects large amounts of personal data relating to its clients to execute their contract. Now, this company would like to combine all data to create a new database to update its price to the market. It's not possible. It's possible only if this company obtains a new consentment for this new purpose, but they can do that if they anonymize their data before to create a new database. Is it clear for you, this point? Yeah? Okay. The first principle is very simple, minimization principle. You must collect only what you need. Only what you need when you start a project. principle is accuracy principle. Means the data controller must keep only accurate data. I advise you to establish a process for check if your data is still relevant or obsolete. If your data is obsolete, please you have choice to delete this data or anonymize this data. The next principle is the retention of data. This principle means you must be limited in time. For example, the data storage concerning your employees details must not be kept more than 5 years after their departure. Is it clear for you, this example? Yeah. For example, is it clear? It's not clear for you. I will have another example.
Because we have a software which make treatments of medical data.
Concerning health, it's different. It's different. Now, today, unfortunately, I'm not the list of all delay, but it's very important to see on our website or your competent authority. You will find the delay, but you will find your delay according to your scope of activity because it's not the same. For example, concerning video watching, the delay it's 1 month.
Okay.
It's 1 month.
Sorry.
Yeah.
Another example, but it is interesting for us. I work with education field also. Sorry for the English, but we have many classes with
11 students.
Sorry. Okay. When the course finishes, we retain the data. We have the names of students of 15 years old. Now we should delete all the students that were in courses older than 5 years, for example.
You should ask the consent at least of the students. Maybe you should ask again if you can keep the data.
Yes, it is possible.
I'm pretty much sure if it's possible.
When
it's possible.
In any case, if I have a person that works with me, now he stops, but I could call him later, 6 years later. I don't want to delete.
No, of course. You're not used to delete, but you need at least to gain or to obtain the consent of those persons, okay?
Yes.
So and then you can action, duration. That's why you will draft like all the mention for those consent. It's going to be easy to get with the
proof
free
of
So,
yeah.
I think, then I stop, one of the most important things is to write a correct agreement with the people.
Yeah. Actually, it's very important what you say because
not software, but write and signatures.
Yeah.
Okay.
It's the best proof. Right and signature, the best. We will continue with the next and the most important principle is data security. Data controller must make sure the data are kept secure against external threats and internal. So, keep in mind, you must have a safe environment. Sorry for my accent. So, you will find in the USB key many examples concerning several actions like data safety policy. You can use encryption process. So look at your USB key, you will find much more information. Concerning breach notification, it's an important point. If you are a data processor, you have to notify it to the data controller in the best delay possible. If you are a data controller, you have 72 hours to notify to the public authority. And you have to notify to your customers too as soon as possible. And what is changing with the GDPR? There is three principles very important. The first principle is accountability. This principle means the controller has to take appropriate technical and organizational measures to be compliant. He has to respect to the principle privacy by design. That means the controller has to include the data protection from the very beginning of each project and not at the end. Finally, the data controller has to respect the principle privacy by default. That means he has to ensure only the necessary data for the purpose will be collected. It's a very important. By default means when you deliver a tool, it must be set up to collect only the necessary data. So data protection is now an integral part of your IT development. So it's recommended to have someone to be a referent to help you in your compliance. The data protection officer. His appointment is mandatory in some cases, but even if you are not in this case, it's recommended strongly to have a referent in your complaint. His mission are to inform the company and its employees of their data protection obligation under the GDPR, monitor the compliance with the GDPR, cooperate with the competent authority, advise concerning privacy matters, and keep registers. What does it mean by registers? The registers is very important. It's the proof that you keep a track of your treatment. It's an obligation when in the company with more than 250 employees. But be careful, even if you have less than 215 employees, you have to have a data protection officer. For example, if your company deal personal data concerning if you have sensitive data, it's an obligation to have a DPO, for example. Concerning the register is different because the content of this document depends on your role. So you will find in the USB key an action plan concerning how we will keep your registers, and you will find an example if you are a data controller or data processor. And in this register, you must indicate if you are sending your data to another country. Oh, it's okay? I'm clear? Yeah? Concerning the transfers outside the European Union, the principle is the prohibition of this transfer. But if the receptor provides the same level of protection, and if this country recognized as adequate, for example, Argentina, Canada, Switzerland, Israel, you have a full list on the USB key. You can make your transfer without any additional action. But for transfer out of this country, several tools have been developed to provide a sufficient level of protection. You can see on your website of your authority, you will find all tools available in your country.
I've got a question, for instance. If you send data to AWS, which is Amazon.
Yeah.
The storage is in Europe,
Yeah.
but the company is an American company.
And the backup could be in the state.
Whereas in this case, since we have the responsibility of not the holding, but the main company, the headquarters, definitely the responsibility of that's why the GAFA and the big companies in the US are extremely concerned by this regulation, because they cannot hide themselves with location based in Europe, not anymore. Even if the data is stored in a foreign country such as an island, we have this famous case in Shrimp, where actually was the exact situation with Facebook, and Facebook tried to define itself with the fact that the data were hosted in Europe, but it's not an excuse anymore with this regulation, which is actually the philosophy behind this regulation. Is try to give the self-certification and to have a responsibility with the major companies based in Europe, Australia, or and so on. So in this case, you need to track back what is the personal responsibility of the company, which technically is the headquarters. But it's yet a question to be answered. No? This is the main question actually. So for sure the European Court will answer to this in a few years, because we have several cases now still in judgment, and the question needs to be assessed. But this is the main reason and purpose of this regulation. And technically, to answer to your question, the responsibility is the one from the headquarters and the company in the US.
And if you encrypt the data yourself before storing it, is that okay or not?
Yeah, it is okay.
It is okay.
It is okay. Encryption, anonymization, and pseudonymization are the three techniques, the best techniques that you all know, I'm pretty sure, to comply with the regulation. That's why there is a lot of drama surrounding this GDPR, but in fact, technically, when you use the appropriate tools, you can definitely comply easily with the data you have. And keep in mind also that we are dealing with personal data, and sometimes you are not dealing with personal data. In my practice, sometimes I have one company is coming and saying, okay, I need to comply with GDPR. It's a big. Okay, what data? What is your treatment, and what data do you store? It's commercial data, and it's possible to track back to person. Thank you very much. Bye bye. Let's see you another time, because there is no need of compliance when you cannot track back to a personal physical person, and this is not the personal data. Okay. Always keep in mind that there is two things: the personal data itself, when you can have the definition, the broad definition of personal data, which is the information, the nominative information of the person. Okay. When each time you can track back to this person, you are in case of personal data. And the second one is the treatment. What is the treatment? It's what Anissa said before: sharing, collecting, storing data. It's the organization. Even if you are a data processor and you're developing a tool for a client, which is a web company, but when this tool, the aim of this tool, the purpose of this tool is to organize data, you are in this category and you are a data processor. Okay, and you need to comply. But treatment and personal data are the two important.
When the client is the owner of the source,
yeah,
you are just the tool.
Yeah,
so
you are the one who organize, you provide a solution to organize the data for your client, and he is the data controller, but you are the data processor in this case. Okay, so that's why the idea and the second philosophy behind this regulation is to responsibilize all the actors, all the chain of actors in the data. Okay, meanings, and of course, as data processor, your level of responsibility is lower than the data controller.
yeah, because if your client asks you to put whatever the social security number or something
Yes.
in that, if he says I want that because it's on
Yeah.
the shop. You are obliged to do it.
Yeah, of course you're obliged. And that's why you are the data processor in this case, and you will provide a technical tool for encryption, for instance, as an asset for your solution. And then, as Anissa said, for accountability, you will find a register for data processor. It's going to be easy to. You will find the list on all the public authorities in your country. It's free, and you comply with this register, and then you're set.
Yeah, but there is also something. Maybe you don't speak about it. It's how do you say that in English? If the company is large or small, if you're a carpenter and you have your clients on an Excel sheet and you also store data, but it's nothing because you have only 20 or 50 or
You're right, but the size of the company is not
normally, but in fact.
Yeah.
Nobody will go to see if the carpenter with his 100 clients will be shared or not.
That's accurate, but technically you're still need to
that's the law.
Yeah, that's the law.
That we are.
But yeah, and of course the practical answer I can give you is like the public authority will focus on the big one and the company or small one, but who are dealing only with data and. Not the bakers.
Excuse me.
No. So the last one is the penalties. The maximum amount of the fine is 4% of your annual global turnover. But if you have a control, it's necessary to understand the first step. First step is not necessarily fine. You can receive a warning with some months to be compliant. And keep in mind. The fine will depend of many points. In fact, the authority will consider, for example, the nature, gravity, and duration of your infringement, technical and organizational measures that have been implemented by your company. So that's why start your compliance. Deploy the necessary measure and demonstrate your good faith. It's a very important point. Good faith. So, thank you very much for your attention. It's time to do best presentation. Thank you.
Thank you, Anissa. First of all, thank you for coming. As a short introduction, I'm Hakim. I'm in charge of technical part in ADVCom, especially on BeSafe Cloud solutions. We will be focusing on hosting specificities with GDPR. Let's start. Hosting and GDPR. The aim of this presentation is only to share experience around GDPR. We are providing classical cloud services such as those listed here, collaboration messaging, document sharing, and so on. GDPR, just take a look on my notes to forget nothing. Sorry for that. Have paper like Anissa. Okay. This is basically which services are concerned with GDPR. All of them are concerned with GDPR, but as we said, the GDPR is not clear enough. So what we already know about cloud providers is that they will have to show compliance with GDPR. So in BeSafe, we've worked on GDPR compliance. For example, our backup and monitoring solution based on RG system, and thanks to them to be there today, is already fully compliant. So please feel free to visit us on our stand and test the solution. Okay. E-privacy. Someone know what is e-privacy? No? Nobody? It's a new law. A new law expected for 2019. It deals with website user privacy, and it comes to extend GDPR. So here's some example of strengthened characteristics. Customer agreement strengthened. What it means for each process, for example, emailing and phone prospecting, you will have to ask user agreement to end user through, for example, checkbox, and one checkbox for each process. Okay, that's okay. Privacy by design and privacy by default, meaning you already know. Thank you, Anissa. Extension of right to information differencing. You can ask to search engine to be unreferenced. For example, today with Google, it's only a manual process. And right to transfer data, we will do on next slide. Okay, as we see, GDPR is not clear enough today, but what we already know is that cloud providers most of the time can be considered as data processor. Okay, and so in this way, they have to appoint a DPO. They have to maintain a log of each internal access to personal data, and maintain also a log for each customer asking. Each customer's request, it means if, for example, you have 1,000 customers, you have to maintain 1,001 log, one for each customer and one for your internal process, and have to give advice as normal for a service provider. Okay, let's play the game together. Case number. Sorry. Case number 1. For example, BeSafe provide messaging services for one customer. Provide services without third party, and all email servers are located in France. So, is BeSafe a data collector or a data processor? Someone can answer?
Which is
Sorry?
it's a data processor.
Sorry, you're right.
I want some too.
Great. Okay, BeSafe is data controller as it provides services to end customer, and it have to appoint a DPO, and the DPO's function is to maintain a log of each internal access to personal data. In this case, it's, for example, restore an email in a mailbox. Monitor mailbox security policy, fight against spam, virus, and so on, and give advice as normal. Case number 2.
But you have a log. You also have a log.
For
you build log also.
yeah,
So
sure. You need to have log for internal for.
So
the first.
What is the difference between to register log when you are a data processor?
Data processor need only to log request from his data controller.
Okay.
Okay. BeSafe hosts virtual machines for a 4D partner. With it maintains systems such as updates and so on, but has no access on database. Such as case number 1, BeSafe has no third party, always located in France, and has no access to database. So who is data controller and who is data processor? BeSafe or 4D partner? Someone? Okay. No.
For the partner is the controller. For the
Sorry.
partner is the controller.
No.
No.
You're right. Is a controller, you said?
Yeah.
Yes, you're right. 4D partner is data controller, as it provides and services to end customer, and have the same responsibility as above for BeSafe. And BeSafe is 4D partners processor and has to maintain a log of each internal 4D partners request.
Yeah, I have a question. I go to the first question I asked you. In this case, the guy who code
Okay.
the data, just the source. It's also a processor, or it's a who is?
You know what? Actually, to answer the question, it's a processor. You know why?
No.
What's the difference between the two cases? It's a matter of words. It's right. In the first case, there is no intermediary. Okay. You look at BSafe provides for one customer. In the second case, BSafe us for the partner. But for the partner is the one who is asking the solution and is the one with the direction, what solution he wants,
But this
so on.
one is the client.
Yeah.
For me.
Even if it's the client, he is the one who provides, all the information.
Who am I in this case?
But you are in the second case, you mean?
In the second case, I'm the third party because I am the guy who code the application.
But you code the application for the partner.
For the partner.
Okay. So in this case, you also are the data processor.
I'm also a processor.
Yeah, you're also a data processor because for the partner gives you the direction. You are an intermediary actually. Your piece of code is going to be integrated in the solution, in the global solution.
Okay.
That's why you're in this case. It's all a matter of change. Actually, when you deal with this, you need to size who is the party and.
Okay. Perfect. Okay, 10 GDPR tips to access your database. It's only general tips because each company has its own processes. First, how to know if you are storing, if you store personal data in your database. You have some indicators. First, the size. If you have 1 terabyte of data, it's likely you have personal data within. Not all the time, but most of the case. Okay, evaluate critical data. We saw what is critical data. It's, for example, credit card number, social security number, and religion, for example. When you have this kind of data, you must appoint a DPO and maintain blocks. And the presence of identifying data. Identifying data, it's when you can link a data to a physical person. So when you have this kind of data, you must be compliant with GDPR. Collect only relevant data. Collect personal data mean additional workload regarding GDPR. So the question is, do you really need those informations? Transfer data to a third party. Imagine the following situation. You have a comparison website and you send personal data to a commercial website, for example, for a checkout, for example. This one cannot reuse those data without user agreement. Transfer data outside Europe, we already discussed about it, but maybe we can add something. Just I check my note. Two things to add. You must know if your data processor is GDPR compliant. And the second point is, in case of data breach, most of the time you are responsible for, because you are data controller. Is it okay? Data erasure. You need to delete periodically irrelevant data and have retention period policies. Just one tip: if you want to keep data for future purposes, for statistics, the best way of storage is to encrypt them. Data security. You must know who has access to the data, keep a log, and maintain and put a restriction and have a restriction policy to control who has access to those data. Sure, it depends on what kinds of data you store. The more critical data is, the more it has to be protected. you should audit your personal infrastructure to be ready. How to adapt your development with GDPR? First, right to access. You must give an access to your end user through a user-friendly interface to view personal data or view and modify all personal data concerning himself, whatever the source. For example, if you collect data from LinkedIn or from whatever the source. Agreements and checkbox we've already talked about. Just one thing to add, if you want to, it could be a good thing to have a method to auto-complete the processing activity log. To auto-complete process activity log, just for saving time. Right to be forgotten, it means likely the same of viewing data, viewing personal data. It's for developers have a method to delete all data linked to a user ID, for example, and give an access to end user to this method through a button for getting whatever you want. Inform third party. If you collect data from a third party, you must inform it that the user wants to delete all data concerning himself, and if the cloud providers offer you API, do not hesitate to use it for deleting data. Export data, always the same. Export data export data in workable and encrypt capable format, and give an access to end user, for example, XML or JSON, as you want. Thank you for your time.